Next, we had alluded to it earlier that we were going to talk about intellectual property rights. Intellectual property rights often are divided into patents, copyrights, and trademarks. We're going to focus more on the trademarks and the patent rights than the copyrights for this discussion. The trademark considerations you probably want are to make sure that the name of the entity that you're going to use is in fact available and you can protect it and no one else can use it for your particular purpose. Often we talk about trademarks and people think about trademarks as a unique name or a unique set of sounds even that are used. So just to be clear, there are a number of different international classes of trademarks. I often give the example of Prince Spaghetti and Prince tennis rackets. Same word, two different applications. So you just need to make sure that what you're using it for, no one else is using it for. Next, we're going to talk about patents. Patents, there's use patents and there's device patents. Here, we're going to focus a little more on the device, the utility patent, so that you're going to look at how your protection works. And you're going to want to make sure that you have as broad of protection as possible so somebody else can't design around you. A good patent attorney anticipates people designing around and tries to get your patent estate as big as possible. Early on, we talked about getting the rights to the company. Here's where, when you have your patent, you want to make sure that all of your employees, all of your founders, and all of your consultants' rights all go to the company so that when the company applies for a patent, it can apply for the broadest patent that it can. Next, when you're talking about having these rights, you also want to make sure that you are judicious in disclosing these rights, and you'll do licensing and non-disclosure agreements. Often with some of these devices, you'll get some of your rights from larger companies that may not want to develop a certain product, but they started to do it, and so you could out-license rights. You need to make sure that your license provides that to the extent there's new improvements, who's going to own those improvements? We've often seen people get rights that are rudimentary in their development, and then the entrepreneurs refine them and improve them, and so by improving them, you own part of the right, and then the underlying license is the rest of the right, and so you end up protecting yourself from a number of people by owning the improvements.
Yeah, and universities are another third party that companies are frequently licensing from, and there's a very kind of set path to getting a license out of a university, and it often involves issuing equity to the university to some degree.
Yeah, and we've seen so there's a number of universities that we've worked with directly. There's also sometimes it's the Office of Research and out of the universities. Sometimes they're looking for equity. What we've seen lately is also sometimes they're looking for a payment upon a liquidity event, and so there's different ways to look at those and what makes the most sense for your particular situation. But intellectual property today is clearly where the majority of the value of a company is going to be located, and it's your ability to make a product that's unique and serves a purpose that cannot be replicated by someone else easily. So
and the brand building goes along right with that. And just back to the trademark point for one moment, the digging that you want to do early on is more than just a few Google searches for similar names. You really want to dive in and make sure that the name that you're choosing to invest in and spend time and money on and create a brand with is really yours to keep. Because we do see with some frequencies companies that get 6 months 12 months, even 2 years down the road, building a brand, and then it turns out that there's a large company sitting somewhere that's using this name in a niche market but wants to protect it and can spend money to protect it, and you can end up in a really difficult set of discussions if you don't discover that early on.
And what we often counsel is that you do your diligence up front, because you always have to be thinking about the next step, your investors, your exit. If your investors are going to stumble across this when they're doing due diligence on you, that's not a good thing, because they're going to think that what else didn't they do that they were supposed to do. So just as we said, you need to have all of your documents in order and be presentable, you also need to do your due diligence to make sure that you're not stepping on the toes of other people. You want the story here to be about your company and your intellectual property, not that your intellectual property or the name of your company or the name of your product could be considered infringing on somebody else's. That's a distraction that takes away from the story that you're trying to tell.
Very different story.
Very different.
Less effective.
Not a good story.